Good afternoon, ladies and gentlemen. I am going to ask you to please forgive me for not having the PowerPoint up that I was hoping to present to you, but they're still working on something and I believe they have some difficulties. I will mention a little bit about Milestone. Not sure if you're all familiar with us or not. We are located in the downtown area, just minutes away from the Orange County Courthouse. And we have our parking is directly across from the library, public library, which is the best way to describe where we're located. I am the business developer for Milestone Reporting. Today with me, you will have an opportunity to meet Mike McDonner, who's the president of Milestone Reporting. I would like to just point out a few of our services. You do have brochures in front of you that include a list of services that we offer. But I'm going to highlight just a few things that I think would benefit you all. Right now, one of the services that we offer is online repository, and that's just so that you can actually, just track transcripts or billing information online, and that's 24 hours, 7 days a week available to you. Our scheduling department is all about obtaining and providing professional court reporters available and videographers available to you across the state of Florida and worldwide throughout the United States. We are a 24-hour business. We will be available to your needs at any time, Monday through Sunday, all 7 days, so that you always have your resources available to you at all times. We are keen on electronics. I see a lot of people use the phones for a lot of things. Through our website, we have an app that you can download, and that app is a transcript app where you can actually obtain your transcripts and just not carry hundreds of pounds of depositions across the country when you travel. You can actually, we offer a free app that you can actually go visit through our website.
Sorry. I want to apologize that this wasn't turned on. We had it all set up and all of a sudden.
That's okay. That's okay. But just so you know, we have an app for your phone, and you can obtain your transcripts through this app, and it's free, and you can download it from our website at any given time. It's a transcript app. We also have an iPad app available. Do you guys use iPads? Yes? Oh, good. Okay. Well, through the iPad app, it allows you to view your video depositions, and you can edit. It's an iPad viewer, and you can edit your video depositions as well. So I wish I could show you the slides that we had available today, but unfortunately this is down. I just wanted to highlight a few of those special things that we offer. One of the main important things I did want to emphasize on was that we're also bringing video.
Sorry about that again.
Okay. That's okay. We're also bringing video to the table. We know video is costly for a lot of our clients, and out there they charge up to $25 an hour for video with a minimum of 2 hours. We are bringing video to our clients by hiring certified videographers. We have them added onto our team, and the video is only $85.65. Hopefully, Mike McDonner will be able to emphasize a little bit on that and give you more detailed information. Otherwise, we are available to go over some information if you have questions at the very end of this presentation. I do want to thank you so much for coming. I hope you enjoy the Latin food. We try making it, with some Latin flair. I hope you enjoy it, and without further ado, I'll turn it over to Vanessa. Please, I'm so sorry that our PowerPoint was down, but there'll always be another time, okay? Thank you. Vanessa, is all yours.
Thank you so much, Evelyn, and thank you again to Milestone for sponsoring. I don't think I introduced myself earlier. I think everyone here knows me. I'm Vanessa Cotto. I'm the current membership chair of the Hispanic Bar, and I do want to give a great thanks to Holland and Knight for allowing us to use their offices for this lunch today. What we're going to do and how I kind of see this going today is I'll be asking our panel of speakers a question, and they'll go through offering their advice. If you guys have any questions at any point, please feel free to ask them. But the first thing I'm going to do is ask a question and then ask the speakers to introduce themselves and where they come from in their background. So the first question I have is, why is knowing how to negotiate important for your practice? And Mr. Albert, if you want to start off. Lead the way.
Okay. You want me to say something about what I do and what?
Yes.
Okay. I'm obviously a senior partner here at Holland & Knight, obviously because of my hair, or lack thereof. And I've been practicing in Orlando for, good Lord, about 35 years. When I first got here, there were 6 Hispanic lawyers. So that was a long, long time ago. 2 of those Hispanic lawyers are now dead. So if you take those out, there were 4 of us. My practice is mainly doing litigation and trial work. I do also white-collar crime here, and this will be my 40th year as an attorney. Prior to Holland & Knight, I was a partner at Ackerman Senefit. Prior to that, I had my own small law firm. I'm bred in Tellechea, so I'm familiar with small law firm practice and all the headaches that has. Prior to that, I was a customs lawyer, and prior to that, I was with the U.S. Department of Justice and the U.S. Department of Defense. So, and you want me to answer the question as to?
Yes. How is knowing how to negotiate important for your practice and for your area of law?
Well, let me tell you what one professor of mine told me when I was studying law many years ago. We were taking a very complex tax course, which I thought was very complex. It was income tax, and he said, "This is the only course in law school that will put money in your pocket the day after you finish taking the course, because you will be able to do your own taxes, and you will be able to save money doing your own taxes, and not only money in what you pay in taxes, but also money preparing your tax return." Learning how to negotiate is simple. Like it's as simple as that. It is probably the one discipline that you can learn during the practice of law that you will use not only professionally but also in your personal life, because you're going to be negotiating all the time. And I don't know if anybody, let's see a show of hands. How many people here have young children? Okay, well, if you haven't begun to negotiate with them, all I can tell you is you will negotiate with them as they get older. So learning how to negotiate is very important also in your relationships, not only with friends, but also commercial relationships. We all have either landlords or banks that we deal with, or purveyors of services that we deal with. All of those are going to entail negotiations. So to me, it is one of those disciplines that you learn, and if you master it, it will put money in your pocket, not only professionally, but also personally.
Okay, my turn. Hello, I'm Gisela Laurent, and I'm the owner of the Laurent Law Firm. My boutique law firm specializes or focuses on family law and criminal defense. I also did immigration, but I'm running for Orange County Court Judge, and so I'm no longer taking any more immigration cases because they normally last about 2 to 3 years to resolve. Negotiation in my area of practice is the key to my success, I believe. A lot of my clients are referrals, and the reason why is because in criminal defense and in family law, people don't want this in their life. They want it to go away as soon as possible. And if you want to take this case to trial, it's not going to go away as soon as possible. So I tell my clients when they hire me, 80% of my cases are resolved by negotiation. And then we try the cases. We try the cases that we need to try, and I save my clients a lot of money and a lot of headache because nobody wants a divorce case to last 2 or 3 years, and nobody wants a criminal case to hang over them for over a year.
Me? Okay. Hi, everybody. My name's Fermin Lopez. I'm with Colin Gilbert, Wright and Carter. Essentially, we're trial attorneys. We're in trial in cases for medical malpractice and personal injury and other, plaintiff-oriented cases where an individual consumer has been injured in some way. And, negotiations, how important is that? As we all know, probably statistically, 5% of cases really go to a jury trial. So that other 95%, we have to try to use that trial as leverage. So, and I think probably as we go through the discussion today, we'll talk a lot about leverage and what it is that you have to gain or lose versus your opponent. And Vanessa and I, we talked about some kind of an icebreaker clip from a lawyer show. I don't know if you want to show it now, but it kind of highlights the way people use leverage, the way people bluff, and I'm sure we'll address a little bit of that, and good faith versus bad faith negotiations. But I guess as long as we follow the rules, we're always going to be negotiating in good faith, presumably. But that's the importance of it. I think as long as we're following the rules and keeping our clients' best interests in mind, we're going to do the important part of that in our practice.
Thank you, Fermin.
My name's Mike McDonner. I'm an owner-operator of Milestone Reporting and also court reporting and litigation support companies across the Southeast. About 60% of my time is in Kentucky, about 40% here. In terms of background, I practiced as a medical malpractice attorney for about 7 years, so I've seen both the active phase of litigation and negotiating settlements, and also I've seen it from the sidelines. Our focus at Milestone and elsewhere in the United States is giving you all the tools necessary to win in a mediation or arbitration. What you show up with and how you show up makes a difference, and as we'll talk about more later, we give you what's necessary to get there. I guess by another standard, I have 5 children, so that makes me the best negotiator here. But in terms of negotiating to me, my other joke is going to be I have to try to get lawyers to pay their bills every day, so it's tough for negotiations. But in all seriousness, since I don't actively practice, I do manage several hundred people, and so it's a different type of skill that you're looking at. We also have what I consider to be a couple of the premier mediation centers. We'll talk about later sort of the importance of having a neutral site, and as working in those, I get to talk to attorneys literally every day about their cases, their approaches, what worked for them, what tools of ours they used, and that's how it shapes my day-to-day activities.
Thank you. So to echo off that, what exactly do you guys do to prepare for a negotiation? If it's for a mediation or just a phone call with opposing counsel, how do you enter that negotiation phase? What do you do to prepare? Anyway.
I think it varies on the area of practice, of course, but I think it's been well written, and I think everybody's experience is probably the same. The more you know about your opponent's needs, or maybe the more you know about what your opponent is willing to leave on the table, that's the best preparation. I don't know if anybody has ever had that experience where they go into a negotiation posture, whether it's a mediation or a phone call, and then the other side's like, yeah, your offer's not doing anything for me. You're like, okay, well, let me see if I can make it a little bit more interesting for you. What if, and then you come back with something else, and the person on the other side, your opponent, is not moving from where they were. Okay, nothing's more frustrating than that in a negotiation. You're basically getting nowhere. And I think that a situation like that is the product of not knowing well enough what your opponent's needs are. And so the preparation of it, to address your question directly, you got to do a lot of research and figure out what it is that you're really up against. Because if you go to a car lot and you say, oh wow, this is a nice car, what's the sticker price? They'll say $45,000. You say, oh man, that's too much. Tell you what, can we get it for $35,000? Well, you're not going to say that with a straight face unless you went and looked at the Blue Book, Kelley Blue Book value, or you looked at what other dealerships might have. And if it's a car that's around that price range, most of the time they're just going to look at you and say, look man, if you want a cheaper car, you got to go somewhere else. And then you got to walk away, So, the short answer is research and knowing what it is that your opponent's willing to give up or leave on the table.
In family law, being prepared for the negotiation or the sitting of the table the preparation is intense. And what I do in my practice is I have a pre-mediation consultation with my client. That, to me, is almost the equivalent of preparing for trial. I sit with my client to see what their expectations are. I run, child support guidelines to show them if their expectations are realistic. I normally will draft 3 or 4 different versions of guidelines based on different scenarios of time sharing, and I kind of give my client that reality check, because early in my practice, family law is very emotional, and I would see that I wasn't doing the pre-mediation consultation back then, and I would go into the mediation room, my client would start freaking out, and I would be like, calm down, it's not that big of a deal, this is, and we would try to just throw all these different scenarios at them, and my client was checking out, and I was just thinking, be strong, we're gonna get through this, keep going. So I'm almost pushing the client, we're gonna get this, we're gonna get an agreement, because you want an agreement, you want to walk out of there with an agreement. And what I would notice is that you'd get that next day phone call, Miss Laurent, I didn't like that clause and I want to change it now, but it's already signed. And so I would have to give them the speech. So I said one day, I was like, why is this happening? And I had to look at myself, not just look at my quote unquote crazy clients. And I was like, maybe I should prepare them for this. And so I started doing the pre-mediation consultation, and I take that very seriously. I want to give them all the possible scenarios. I want to know, like you said, the opponent, what are they going to want? If I know from the pleadings that dad wants equal time sharing and my client's like, no, he's not responsible, I have to walk my client through all these scenarios, or how can we make this meeting in the middle without being scary for my client. And then when I go in, I tell my client, listen, at mediation, I'm going to go in there sweet as honey, because you're not going to reach a negotiation being like this pit bull, this is what we want, and we want this, and we're not settling for anything else. So I said, don't be caught off guard if you see me and we're all happy and everybody's, warm and fuzzy, and we're trying to move forward your position. I think it's so important, because we want to go in there as lawyers, and we want to go in there rough and tough. But you go in there rough and tough for a negotiation stage, you're not going to get far, because no one's going to give you something when you're barking at them. I think, my professor in law school would always say that they wanted the person to be shocked at trial. Where was that nice lady from mediation or, deposition? Where did that girl go? And I always keep that in mind. I go in there prepared. I go in there ready to negotiate, ready to bend within the parameters that my client is comfortable with. And it helps with the negotiation, because a lot of times I've been able to break down the opposing party and not break down the opposing attorney, because the attorney will be like, this is what we want, this is what we want to do, and I'll just make eye contact with the other person and say, okay, forget about all this stuff, how does this work on an everyday basis? If someone's saying, I want 50-50, okay, let's not talk about how many days of the year you want. How do you see this working on a weekly basis? And just bring their guard down, make them say, hey, we're trying to work together, we're trying to reach a resolution. And that's what normally is that breaking point in the agreement and negotiations.
Wonderful. Thank you. Any other thoughts?
Sure. Okay, I think preparing for mediation, you're going to have to kind of define what your audience is going to be. If you're a plaintiff side of the equation, and you're dealing with an individual, your preparation is going to be a little bit different than if you're dealing on the defendant side or you're dealing with a corporation. Usually when you're dealing with a corporation, at least the corporations I deal with, you either dealing with pretty much savvy individuals who've been themselves negotiators, not in the legal sense, but at least in the business sense, or you're dealing with general counsels who have been negotiators like you. So that kind of preparation is going to be a little bit different than when you're dealing with individuals. But the preparation for mediation actually begins when you take the case on. If you have been telling your client all along, your case is a home run, we're going to win it, we're either going to destroy the opposite side, which I think is a very poor choice of words, but if that's what you've been telling your client. And now when you go to now you're getting ready for mediation, you start trying to tell him what the weaknesses in his case are, you're going to have an uphill battle. So I think from day one, from the very first day that you take the case, you have to be open with your client, you have to be truthful with your client, you have to be able to assess the case in an objective way and tell the client these are the high points and these are the blemishes. Every pig has, you can put lipstick on a pig, but you know what, still gonna be a pig, okay? So that's the first thing, you gotta start with preparation. Second of all, you gotta be very careful on who you pick as a mediator. Some mediators, I would never mediate a case with some people that claim to be mediators in this town, because the mediator's role is to be not only a facilitator, but also the mediator's role is also very important of when he's going to say, we're going to declare an impasse. What you don't want to do is you don't want to be going through 2 days or a full day of mediation, like what you said, when the other side is saying, nah, that's not good enough. Nah, that's not good enough. At some point in time, your client's going to turn over to you and say, I'm not going to continue bidding against myself. Let the other guy's side put something on the table. If you have a mediator that is not experienced or doesn't really know what he's doing, he's going to keep you there, and the clock is going to keep going cha-ching, 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 when in reality there's not going to be any possibility of mediation because you're not getting any feedback from the other side.
And that raises something interesting. I don't know if you all have ever had the experience where you've got a client who has a business background and thus an experienced negotiator in business, maybe not in law, but some experience negotiating. And then you've got what we might refer to, and I don't mean this in a derogatory, just somebody who's not a sophisticated client or not a sophisticated negotiator. Sometimes that's the worst negotiator to go up against because they really don't have a sense of what they'll lose if they don't try to, agree to some of the bargaining that you're offering. And then as far as mediators, I don't know if y'all approach mediation this way, but I find myself negotiating with my client at mediation to try to get authority, right? So I can try to get things moving. But then I got to negotiate with the mediator because though the mediator is supposed to be impartial, the mediator has a side. It's not my side, it's not my opponent's side. It's the side of, hey, I want to get this case resolved so that I can get people to like the work I do and then get more business and so on. And sometimes the mediator, you can read right through them, they're trying to get you to come off of your position. And so one of the things, and Lewis always makes fun of this, but it's true, you got to implement what we call the flinch test. Other than Lewis, let me see a show of hands. You guys know what the flinch test in negotiations is? Yeah. All right. So for those of you who don't know what it is, it works in every category of negotiations, whether it's
home all the time, just put that out.
Yeah, there you go. It works in private life, it works in the professional life. The sample is, and this is from a study that was done by some folks up in Princeton, but if you go to get an eye exam done and the person that's going to charge you money for your eye exam says, all right, listen, we're going to go and do your eye exam. It's going to be $100. And if you flinch, all right, one way or the other, they have a prescribed response to your flinch. All right, hey, your eye exam is $100, and you go, whoa, $100. The optometrist is going to say, oh, but that's for both eyes. Okay, so then all of a sudden, psychologically, you as the consumer are like, that's still a lot, but that's not as bad. Even though you probably thought it was per eye anyway at the beginning. Now, if you don't flinch at the $100 price mark, all right, the optometrist is going to say, hey, it's going to be $100, and you go, oh, okay. The optometrist is going to gauge that flinch or lack of flinch, and then he's going to say, oh, but that's per eye. Okay, so depending on how you react, it's going to be a $100 eye exam or a $200 eye exam. Okay, and just the other day, I had floors redone at my house, and the guy that came over to do the estimate, he measured everything. He goes, all right, I think we can do this for about $13,000. I did not mean to flinch, but I couldn't help it when I heard that price tag. And I let out a cuss word. I said, holy, are you serious, man? And I said, I can't do it. And I was willing to walk away. And he goes, well, now, hold on. See, that's what happens with a salesperson, all right, a sophisticated negotiator, but they can't walk away. knowing what it is that they need, they gotta make that sale. So we ended up getting it done for like $9,000. You know, it was still a lot, but that flinch that was completely involuntary, I think is what got me there. Now, and you guys have all, I'm sure, done it, or you will do it more now that you're more conscious of it if you weren't, but if somebody says to you, hey, look, this car is about $30,000, and you go, hey, that's not bad, you're the sucker. All right, that salesperson's going to say, all right, good, because then after that, once you try to say, hey, but can you bring the price down, they're going to say, nah, I can't, that's as low as I can go. They already know they got you hooked. All right, but if you go, ooh, 30,000, man, that's kind of high, they're going to want to work with you. So, you know, I always recommend keep the flinch test in mind, because it just seems to work, especially with clients, the more sophisticated clients.
We look at preparation a little bit differently. I agree with literally everything they've said about how attorneys approach it. But on the litigation support side, we have to look more of, one, the facility in which you're going to conduct it, and two, how are you going to present everything that you know, which is the most important aspect of negotiation, have asymmetry of information more about what your opponent needs than he does. But how are you going to present that? And a whole lot of what we do is through video discovery and having the clips available necessary. We've attached sort of a PowerPoint presentation here because it's dead, but it goes through a lot of studies that say people make up their minds and assess one another or the validity of another person's position within 6 to 30 seconds of looking at that person and listening to that person. And being able to have just a few clips that accurately, or in a very poor light, demonstrate your opponent's position and show those to the mediator and show those to the representative. Maybe you got a corporate rep there, and for the first time he's really hearing the testimony of his former employees and seeing just that worst sliver. That's going to make all the difference in the world of you trying to sit there and tell them what happened or tell them about your case. They've read it. They don't want to hear it again. You've got to show it to them. And that's what we do. We can prepare you in a way that gives you tools that make all the knowledge you have twice as powerful. And the only other thing I'd touch on with respect to location, again, there's tons of studies on this topic. The more confident a person is in where they are and in how their day is going, the better job they'll do. You can literally sit there and think about the time that you were the most successful in your life. I don't know if it was homecoming queen or winning the big game, but if literally you go through that in your head before you go into negotiation, the studies show you'll do a better job and you'll be perceived as more persuasive. Well, if you're going to your opponent's law office to conduct a mediation, and usually it's some gorgeous facility like this that's built to impress to begin with, they're feeling at their best and they're most secure. You're already at a disadvantage. You're thinking, wow, this guy's office is better than mine. You're not going to be as aggressive. I don't know how to explain it, but it's psychology, and somebody who's smarter than me can explain it to you, but I'm telling you that's the truth. So if you can't do it at your own place, find a neutral site, and of course, shameless plug, that's where we come in. We have great neutral sites that you can also be comfortable with. So we look at preparation a little differently than the lawyer, and that's how we help.
Great. Aside from the flinch test, I think this really leads into the next question. What else do you do to assess your opponent, or how do you maintain control during the negotiation?
Maintaining control during the negotiation. I think you can try to direct the negotiation, but it's very difficult for you to actually maintain control of the negotiation. I mean, control the negotiation, if you're going to be writing a check, obviously you have a high degree of control because you can always say no. All right? But I think that the one thing that helps you guide the negotiation and determine which way the negotiation is going to go, it's going to be asking very frankly and determining very, very early in the case if your client has the stomach and the wherewithal to go to trial. Because if your client doesn't have the stomach for or the wherewithal to go to trial, and by stomach I don't mean the fortitude, I mean your client may have the greatest story in the world, but if he is a terrible presenter or has given the 5 different versions of the same event, your client is not going to be a very good advocate for his side of the story when he tells it either to a jury or to a judge. Okay. So if you have what I will call a trial issue, that's going to affect on which way your negotiation is going to go. And very quickly, if you have experienced counsel on the other side, counsel is going to know whether you're willing to push it to the limit, meaning, like what you said, you're willing to push away from the table and said, you know what, no, this is not going to do it for me. You know, I made a reasonable offer. You're coming back with an unreasonable number. We'll just let the jury decide it, or we'll just let the court decide it. Okay. It is a great opportunity for you to be able to talk to opposing client, not the opposing lawyer, but to opposing client directly. It's actually the only time that you can talk to a represented party directly without incurring the wrath of the Florida bar. All right, so that is very, very important. And it also gives you a good feel for whether the other side actually wants to go to trial or not. And we have all been in mediations where you know by just the demeanor of opposing counsel or by the client that they're not going to go to trial. You may not be able to settle the case of mediation, but you know what? You know, a month before trial, they're going to give you a call and said, you know, we thought about it. If you can raise your offer by Y, we'll go ahead and take it. So I don't know if I would couch it in terms of control. I would just couch it in terms of guiding the mediation in a way that that is going to be profitable. And remember, the purpose of the mediation is to reach a resolution. Your client is not going to be doing cartwheels when he leaves because he's going to have to write a check. And the other side is not going to be doing cartwheels because he may have had an expectation that he was going to guess Y and now he's getting X. It is just a resolution.
The one item when it comes to controlling that's always common, because I deal with a lot of attorneys and they're always sitting in the office talking to me about what they do, and it's anchoring or making the first offer, which I'm really interested to hear what these guys think because it's all across the board. The studies show the person who makes the first offer usually has the most success, because once you create a starting point, then the whole rest of the negotiation is going to be how far away from that starting point are we going to go. The other school of thought is, well, don't come out and show your cards early. The scientific literature says you're better off being the first one to the punch. Make an offer, nothing insane, but higher than what you want, or lower than what you want, whatever your perspective may be. And from there on, all the discussion is going to revolve around how far they're going to go from what you started. Don't let the other person take the initiative. But I'm curious how the others think about that.
In my practice, in mediation, we give out our offer in our opening statements, pretty much. I just lay out the facts of the case, and this is what we're looking for. So I just throw it out there. So I guess I'm easy when it comes to mediation. But I think as far as our strategy and control, I like to be the person who sets the mood, and I always call it like just being the bigger person. I'll tell you what we want from the beginning, and I believe that's like the median point of what I've come up with my client at our pre-mediation consultation. It's probably not the best thing that she wanted, because we're not going to be radical people. You know, it's not the most that we're willing to give. It's our medium point. And no matter what happens, my client wants to jump out of their seat, I try to control my client. I try to make my client, prior to mediation, feel confident about themselves and their position. Even sometimes I'll have, if I have a female client, I'll tell her, get dolled up, look your best. This is your ex-husband or soon-to-be ex-husband. We're going to go in there, and you know how to work him better than I do. So wear his favorite dress, wear his favorite cologne, and we're going to work this room. And so I control
Manipulation.
It works. Let me
It
tell
controls.
you. I've had two funny cases. One, my client, she got her hair dyed. She got, a nice little appropriately tight shirt with a button that was almost going to pop. And she got everything she wanted, including the alimony. And they got back together after the mediation. And I had, hey, if they divorced, I would be their attorney again. But and then I had one client that the attorney and I ended up going to lunch because the parties ended up going to a hotel. And so that can happen. That can happen. And so setting the mood to me is important. It's going to get me where I want to get. I have attorneys all the time that they're like, very aggressive. They want to spoil the mood that I've kind of created for my mediation, and I won't let it happen. I'll talk my client down. I'll separate the rooms, because you can caucus. If you think the mood is not right, you just say, let's get separate rooms. I'll talk to the attorney directly. If I have to get aggressive with the attorney one-on-one, say, listen, this not gonna go anywhere. You're gonna crash this train. Let's regroup, let's get them back together. And sometimes when I think the attorney is too much of a push and it's gonna ruin the mood, I say to the mediator, hey, why don't we let the parties go in there with you by themselves? Because my client's already been trained, at pre-mediation consultation. And so, sure, why not? Okay, go. And then they come out with the agreement that we wanted. So you have to just be creative and just always remember that you're going to get an agreement under a better mood. So you got to control that mood.
I think you've raised an incredibly important point, which is the importance of the mediator. A good mediator for family law might be a terrible mediator in a commercial case. And a very good mediator in a commercial case may be a terrible mediator in a personal injury case, because their way of looking and approaching the case is totally different. Okay, it's totally different. In a commercial case, invariably, it's going to deal with numbers. In a family law case, the mediator is going to have to deal with heightened levels of emotion and perhaps a lot of anger. And in a personal injury case, it's going to have to deal with physical impairment and understand that physical impairment. So that's why picking your mediator to fit the type of case that you are going to be trying or you're going to be presenting, it's very important. And if you get a family law mediator to try to mediate a commercial case, it's going to be an interesting experience. Let me put it this way. Your client and the other client are not going to go off to a hotel together.
I was going to say,
at least not likely.
one type of mediator that I have a personal bone to pick with is federal magistrate judges. I used to have a lot of practice in federal court. I am convinced, and I think it bears out, that their sole job is just to clear dockets. They don't care. They just want to get the case off the docket so that senior judge doesn't have to try it. I had a magistrate told me one time, Mike, you were going to lose this case and you're going to get hit with punitives 100 times out of 100. And my response was, well, I must have the literally worst clients in the world, because every single time I'm with you, you're telling me how I can't possibly win. We, of course, won that. The jury was out for like 15 minutes and came back in our favor. But their entire goal is just to force people to a resolution. They're not interested in hearing your perspective. They just want to get it out the door. So understand the agenda of the mediator you have when you can't choose them. And I hate magistrate judges.
Yeah, I don't know what your experience is with federal magistrate judges mediating cases. I don't know if anybody else has. But as a rule of thumb, I will not pick a federal magistrate to mediate a case, because somewhere in the back of my head, there is this image that the judge is going to pick up the phone or walk down the hallway and talk to the mediator about what happened in the mediation. And I just don't, I don't want that relationship to exist. Plus, he's going to be the one that's going to be deciding all your pending discovery motions. I don't want him to be tainted by a perception that you're being, or the other side is being unreasonable. So I, as a practice, will not mediate cases before federal magistrates.
What do you guys think is the difference between puffing and the unacceptable lie?
That might be one of those, a difference without a distinction kind of
Well, no, there is a distinction.
I'm kidding.
Yeah, there is.
I think that in my area of practice in family law, there is overwhelmingly, unfortunately, a lot of I'm going to report you, because they want their way in the family law case. So if there's tax evasion within the family, and the husband is the one that runs the business, you'll see a lot of attorneys say, I'm going to report you for this. Or if one party has recorded the other party unlawfully, I'm going to report you for that. And puffing, threats, extortion, because sometimes they'll say that. I think the difference is you as an attorney need to be strong enough to know that if they do that, they're bringing the whole family down. So whenever I have somebody puffing, oh, I'm going to report this, I'm like, go ahead, because your client's going down too. And then there's not going to be any alimony. There's going to be some foster children. There's going to be foster parents in these kids' lives. That's the road you want to go down to, and then it calms down. Because again, I think it's all about controlling the mood. You have to show you're not afraid of these puffing And I haven't had anybody ever lie. I mean, I truly think that people, when they say that in family law, they mean it. Like, they think that that's a good strategy. But if someone's going to jail, more times than not, it's not helping the family as a unit. And so you just have to be strong about your position and not be afraid of that, because you're going to tell your client, this is what could happen. Will she do it? Will he do it? I'm not sure, but that's what they're saying. And make your decision from there. Just be confident.
If nobody has anything to add, I like to think of, I don't like the word puffing, but I like to think of advocacy. I mean, you're advocating your client's position, so you're going to present the facts in the best light for your client, because basically your audience is opposing, not me, opposing a lawyer, but mainly my client. All right. But if you lie, outright lie, I think basically what's going to happen is everything you have said and everything you will say during that mediation from that point on and that point prior is going to be called into question. So that credibility that you're trying to build, so that my client, when you tell him, look, your position is unreasonable and here it is, A, B, C, and D. If the next thing you say is a lie, an outright lie, all of that building up of credibility just goes down the toilet. And contrary to you, I've been in mediations where opposing counsel has flat out lied and said, well, the judge in this case ruled that the contract was not enforceable because it was fraudulent. And, you know, the client turns over to me and said, when did that happen? And I just looked over to him and says, do you happen to have that order with you? And of course, then it's well, it wasn't really a ruling, he kind of implied it. But what I'm saying is, once you start going down that slippery slope, you lose the credibility. And at the end of the day, if my client is a plaintiff, you're trying to get my client to go from here to here. And if my client is a defendant, you're trying to get my client to go from here to here. Either one of them have to justify their decision, either to themselves or to upper management. And if they can't believe what you are telling him or telling her, then how is he going to justify that decision in his mind or upper management? So lying is never, ever, ever a good idea.
I think this is a perfect segue into our video clip. I'd like to show you guys just a 4-minute clip from the show Suits. Fermin, this is, if you want to set it up.
Go and pause it for a second, William. It's an interesting clip, and Vanessa and I talked about this because it seems to summarize some of the stuff that we all would see in negotiations sometimes, and some of the things that we shouldn't see in negotiations, and some of the stuff that works and some of the stuff that probably wouldn't work in real life. But add to that, it's entertaining.
I'm paying you millions. You're telling me I'm gonna get screwed? Jessica, am I coming to bad time?
Gerald, this is Harvey Specter. He's our best closer.
Well, if you're the best closer, where the hell you been for the last 3 hours?
Well, Gerald, I specialize in troubled situations, and when I left here at 7 p.m., this deal wasn't in jeopardy, so I'm just trying to figure out what happened in the interim.
We keep offering more money, they keep rejecting it. It's last-minute bad faith bullshit.
It says here that Cooper won't be staying on as honorary vice president.
That's right, I don't want him around.
He wouldn't be around. It's an honorary position.
I don't give a shit.
Well, I think you do, because that's what's changed since I left, which means it's you who's been dealing in bad faith.
Well, now that you've got a grasp on what's happening in the goddamn interim, what are you gonna do about it? Because he's not getting that title.
Well, let me make sure I understand this, okay? We negotiated a deal that gave you everything you wanted. Mr. Cooper signed it. And now you won't close until we take away the last shred of his dignity.
Bingo.
Well, that's not gonna happen.
And why the hell not?
Because I like Mr. Cooper, and my firm doesn't operate in bad faith.
Oh, I see how it is. Instead of working Cooper, you're working me. Well, why don't you take your pansy attitude back in there and make him sign my deal? Or I'll pay someone else your money to do it for me.
First of all, Gerald, if you think anyone's going to touch this deal after your bad faith, you're mistaken. Second, the way our agreement works is the minute Cooper signed the deal, which gave you everything you wanted, our fee was due and payable, which is why at 7:30 I received confirmation of a wire transfer from escrow indicating payment in full. So I'd say the ball's in your court, but the truth is your balls are in my fist. Now I apologize if that image is too pansy for you, but I'm comfortable enough with my manhood to put it out there. Get your ass in there and close the goddamn deal.
You let him talk to me like this?
Harvey speaks for the firm. We got paid before Gerald signed the deal.
What are you talking about? This is a memo about some fire drill on Tuesday. You're the blue team captain. You get to wear a fire hat.
All right. So thank you very much, Fermin, for that clip.
Sure.
What can we take away from that clip and from that show and from how he dealt with the client?
So I guess one distinction is puffing versus bluffing, right? You know, if you're puffing, I think, as we all probably agree, you know, you lose credibility. When you're bluffing, you got to be careful that it's not something that they can discover later on. Problem is, Florida bar rules tell us we have to negotiate in good faith. You know, we have to, you know, be honest about things. But, you know, this is one of those situations where I think it came down to eye contact, really. And if what I try to do, but it's hard to do because we have to be efficient with our time, if you can meet with the people that you're going to negotiate with, so mediation is that occasion, but really when you can look at somebody in the eye and try to close the deal, so to speak, that's huge. And so one of the things I do, similar to what's been suggested at mediations, is if we're getting to a point where, you know, it's about time to get things resolved, I go to the mediator and I say, hey, can I talk to the other side directly instead of having you be the messenger? And then I just go in there, I sit down, I look at him in the eye, and I say, look, this is what's going to get it done. And 9 out of 10 times, it gets it done. You know, so that's kind of what I take away from this, putting aside the unethical behavior that we just saw.
But you can get away with, that is successful because you build up the credibility.
Right.
If you have no credibility when he goes in that room and says this is what's going to get it done, they're going to look at him in his face and they won't believe it.
The comment about doing face-to-face is invaluable as well. That the studies will back up that more information is conveyed by the body and mannerisms of the individuals than the words they ever say. So even when you get stuck in those mediations where you're compartmentalized and you're negotiating in separate rooms, when you come to, hey, I want to make my offer up to $100,000 or whatever it is, you ought to ask the mediator, I want to go in and tell them why we're raising the offer and what it is, so that you can gauge the reaction to it. Otherwise, you're relying on that mediator to filter it for them. Some mediators won't do it, some will. If you can, you probably should.
Yeah, and that brings us to the new phenomena that we're seeing, I think, more and more often in this district or in this circuit that used to be the case, which is where the judges are allowing one of the parties to appear at mediation by telephone. To me, that is, whenever I get that request, and if the judge authorizes, I've never had a mediation that has been successful if the deciding person appears by mediation. Now, if he's a remote party that really doesn't have anything to do in the case and he's in there just so that you don't have an empty chair of trial, that's a different story. But if the main person, the person who's either going to be making the decision or not, is going to appear by phone, it's not going to work.
Just because it is getting close to 1 o'clock, I have one final question.
Do we get to negotiate that?
He's been waiting.
Can it be sooner?
Well played, well played. What is the best piece of advice for negotiating that you could give to a new lawyer? And is there any reading that you would recommend for us, or perhaps any show that you would refer us to watch?
Okay. Since I guess I'm the oldest, I think that's unanimous. I think mediation is, no matter how difficult you think it's gonna be, it's a great advantage, to you, because you're gonna get, not only you're gonna get to talk to the other side, but you're gonna get some very great, priceless discovery of the other party's side of the case. But if I have to give an advice, is preparation, preparation, preparation. If you're gonna advocate, know your limits of how far you can push or you can interpret the facts. I would say never, ever, ever lie. And if you're going to go to mediation, you have to be prepared to walk away from it. If you go to mediation with the idea that no matter what, we cannot try this case, then, as they say in the criminal system in federal court, it's a slow plea to life. Okay, so those are the things, the takeaways for me.
I think he stole my answer.
I'm
But no.
sorry.
No, but I think preparation of yourself and preparation of your client, as we've said throughout this discussion, is so important. But also, taking from the what to read, know the case law regarding the area that you're negotiating is so important. I can't. It's happened to me so many times that I go to a mediation and something as simple as distribution of student loans that were during the marriage, and I've gone in there and you'll have a mediator say, well, that's not a marital debt, and I'm like, okay, and then the next mediator say, well, that is a marital debt. So you need to go in there with your case law. You can say, listen, this is what it is. Now we're willing to negotiate that, but this is a marital debt, and have your case law with you, because the mediator's going to say they're not a judge, they don't have a dog in the fight, but they will push positions that they believe to be the way the law is going to turn out. Like our Milestone guy, I'm sorry, Mike said, they'll push their agenda in a way that they believe this is not a good case. The case law is against you, so have your case law with you to show that the case is in your favor if you want it to be, but you're willing to negotiate. So that goes into preparation and being prepared, because you have to know the case law regarding the issues, or the statutes regarding the issues that you're going to be negotiating.
It comes down to risk tolerance, and that's a kind of a funky phrase, but we talked earlier about preparing your client from the very beginning. We sometimes refer to it as curbing expectations, but really it's being realistic with the expectations that your client should have. And when you start telling your client, oh, we can win this case, this is going to be a great outcome for you, that's a disservice to your client. 1, 2, you're lying, because you don't know that. Nobody knows. So telling the client, look, we're going to do our best, I feel good about it, I can't guarantee you anything, and start preparing them for what's going to be their risk tolerance, because by the time you get to actually negotiate, your client has to figure out, 1, are they willing to walk away? And that's huge. You have to be willing to walk away if you're going to say, hey, look, we'll see this in front of a jury if we don't work things out. You shouldn't bluff about that, because then if they call you on it, then what? All right. 2, as far as risk tolerance, if your client is one of those people who's just like, look, I just want this all behind me, that's probably the biggest negotiation tool I use when I'm negotiating with my clients. All right. I negotiate with my clients probably more than with my opponents. And the biggest negotiation tool with clients, isn't it? Right?
It is. It's so
Yeah.
true.
I mean, I do more lawyering in my office with the person that hired me. But I always tell them, you know what? What's it worth to you for all this to be gone? The value of peace of mind. All right? There's no longer a divorce. You're not facing jail time anymore if you just agree to, probation. In my case, look, it's not the amount of money you wanted, but it's around the range of what a jury would find. But how about the price you can put on closure? You won't have to hear from me again in 30 days, and that's always, I think, valuable. And as far as preparation, this is a silly phrase I picked up a few years ago from a friend of mine, but it's so much better to be the hammer than it is to be the nail. And so if you're the one that's really on the offensive leading up to your mediation or the negotiation conversation, you're the one that's been hammering, not getting hammered, it's more likely than not going to fare better for you and your client.
It's always tough going last, because I agree with everything they say and can't add a lot. But what's most important is preparation and understanding your case, and then thinking about, I think as he was saying earlier, from the day you sign that client, what are you going to be telling the jury at the end, or in this case, the mediator, and then how are you going to convey it? I usually use the example on PowerPoint of, I've got this witness who's terrible. The witness does a terrible job, and how am I going to prove it? And then I have this transcript, and I read the transcript to try to convey to a mediator or juror, this guy's just out of control, and the transcript, it does nothing. But then you pull up a video, and of course in this case it's a video of Justin Bieber, and he's popping his collar, winking at the camera, rolling his eyes, spinning in his chair. A 10-second video clip of that witness does more than anything you could possibly say. And that's where a young attorney can find some confidence and some assistance in, again, shameless plug, companies like Milestone, because we have the collective knowledge of doing this for hundreds of attorneys, best attorneys in the Southeast, over and over and over again. We know exactly what type of clips they want, what looks best. We can help make sure that you have those assets for you when you get there by making sure you get affordable and accurate video clips as well as written transcripts. And then when it gets ready for presentation time, we have trial presentation specialists who can quickly and effectively meet with you, get to the point, and put it in a format that's easily demonstrable so that it has an impact. Don't reinvent the wheel. Don't go out and try to learn trial director 2 weeks before. Do what you're best at, knowing your case, knowing the law, and the littler things. Find the people who are best at it and rely on them. Of course, hopefully that's us.
Thank you. Do we have any questions from our guests today?
Before we go to questions, I'd like to put a plug.
Yes.
I don't know if you guys can see this. This is an old book that I picked up when I was in law school, so it's pretty ancient. It's called A Lawyer as a Negotiator. It's an excellent book. There's case law cited in there, but I would not recommend it to you because of the case law, because the case law is very antique. But it does have a lot of excellent pointers as to everything that we've been talking about. And if you guys go on Amazon.com, there's only one copy available. So, and it's only $11. Okay, so if you guys want to borrow mine, where's Lois? Lois, if you sign in blood, I'll let them borrow my copy. But if you go to Amazon.com, I recommend it. Buy it. Go through the index. Pick what you want to read. But it's an excellent book. So if you can get it, get it. Like I said, one copy in Amazon. That's all there is.
I think Fermin just snapped it up, actually. I did see one
click.
hand go up.
Yes, I just was going to ask, how do you guys choose a mediator? What do you look for in a mediator?
For me, it was always trial and error because we have a list of family law mediators, and I would just try them out and see if I liked them or not, and then you kind of get a list of the ones you like. There's a list in my office of the ones you do not use under any circumstances because of bad experiences. But you can talk to other lawyers. And sometimes I've worked with other attorneys. We've got to pick a mediator, and we each give 3 names, and we'll figure out which one we like. But ultimately, everybody likes mediators for different reasons, so you're going to have to try yours out to see, whether the dynamic fits with your style and their style.
There's a tactic I use, and I don't do it for fun. I do it because it's important. When my opponents say, hey, who do you like to use as a mediator? I say, I don't care. Okay? I don't care. Basically, I'm saying this case is so winnable, it doesn't matter who we use as a mediator, whatever you want. But then if they fire back with like a couple of people, I'm like, okay, except for them. I just remembered a few years ago, I had them and they're just not very good. So that's one way. Another way, you check around with folks and people will tell you basically what I said, do not use so-and-so. That's the last part. And then other people say, if you want, for that kind of case, use this lady or this guy. But it's word of mouth really that gets it for you.
Yeah, I try to pick the mediator for the case because, just like he said, some mediators are better at some type of cases than others. I use the mediator that we keep going to, at least I do, is Jay Cohen. But I do it because if you get to talk to a federal judge here, they always speak volumes of him. So if I'm, and it's easier to use somebody that, especially when the mediator is going to be in the case management order, it's always easier to get the judge to go along with your or your proposed case management report if you use a mediator that they're familiar with. But I pick the mediator to the case and also by word of mouth or people that I've known. I mean, if you've been in this community as long as I have, you usually know who to stay away from and who not to use, or who is good, who's going to have good rapport with your client. And if you can't, then pick up the phone and call one of us. I'm sure between the four of us here, I'm sorry, between the three of us here, if the mediator is good, we probably have heard of them. And also among the association themselves, pick up the phone and call all the members of the association.
And all joking. Well, no, but all joking aside, we do have, if you were going to ask me personally, what I would do is turn to one of our resources like a Lori Carpenter or Paula Leeper or Z, who knows everybody in town and can give you those suggestions as well. So I don't want to feel like I'm the carpetbagger from Kentucky.
Do you have any other questions? Oh, yes.
What are the red flags for you that indicate that negotiation is not a good avenue for your case?
Did you guys hear her question?
I did.
Yeah.
I never think that, at least in my area of practice, mediation is mandatory.
Yeah.
So we have to attend mediation. We have to try to negotiate. And if I think that the person is just their position is unreasonable, I won't spend. I will do that. I will not spend my client's money having me sitting there going back and forth with somebody who's unreasonable. I'll go ahead and tell them, listen. At my pre-mediation consultation, I'll say, if the other party takes a position that's completely unreasonable, we'll just say, forget it, impasse, let's leave, and then save your money for trial. Because that's just going to happen sometimes, and that it boils down to, are they trying to work with you, and their body language. If you got another party that's arms crossed and they want everything, and they're not willing to give you anything, then there's no reason to waste your time sitting there.
There's two approaches I have when I think it's a case where mediation is pointless. And it's really so sad when that's the case, and you can tell pretty easily. One, you can file a motion with the judge to have the judge do what's referred to as set aside mediation, and you have to show good cause. All right, that's the standard. Good cause might be emails that you have back and forth that will show, judge, we're not going to get anywhere, we're so far apart. All right. Nonetheless, judges still think that if you get a mediator in place, they can talk some sense into the parties. So they don't get granted that often from what I understand. But the other thing that I think is important, if you know the case is not going to settle at mediation, I think it's worth the expense for that first hour, because mediation opening statement is where your opponent shows their cards. They're hoping, if you haven't signaled otherwise, they're hoping that they might persuade you at the mediation opening statement and then through the mediation process. And sometimes I've gone to those mediations and my opening statement is, basically, we disagree with you, we're ready to go to trial. The other side says, all right, well, here's how we see the case. And then they'll spend 15, 20 minutes highlighting what they like about their case, and all of a sudden I'm just taking notes, and I'm like, oh, so I thought they might go that way, but I wasn't sure if that was really going to be their preferred poison. So it's an investment, even if you're not going to settle the case, so that you can be better prepared for that next phase.
Yeah, I think that the issue of whether your case is good for mediation or not is almost like a dead issue at this point, because at least in Florida, and I cannot address any other state, you're going to have to go to mediation before you go to trial, whether you're in federal court or you're in state court. Okay, so I think that the point that was raised by Mike?
Yes.
No, by
Fermin.
Fermin. It's an excellent point. Mediation is an opportunity for you to talk to the other side, to hear what the other side theory of the case is. In other words, you're going to get free discovery and total unfettered access to talking to the opposing side. In other words, directly to the opposing side. And I tell my clients, look, even if you don't think that this case is mediatable, in other words, resolvable, the value of that discovery and the value of talking and assessing the way the other side is going to present their case for purposes of trial, to me, is worth a couple of hours of time and 1 hour of the mediator's time, because remember, you split the mediation 50-50 to invest that. And at some point in time, you're basically going to pull back from the table, you're going to look at the mediator and say, you know what, this is not going anywhere. So we're not going to raise our offer, so we'll just declare an impasse and we'll go to trial.
And by the way, I just remembered, I've had a couple of cases where going to mediation, I was like, this is such a waste of time. I cannot believe we have to go through this. I could be doing other things. My poor client has to get dressed up and come. And I show up to mediation, I don't bring anything. And I just sit down and I do my opening statement and I say, look, we're not optimistic here today. I don't see how we could possibly reach an agreement, but we're here because we have to be. Thank you. And that's all I've said. The other side starts telling us their whole case. The case has settled 3 times that I can remember now. And the mediator in one of those cases told me, somehow you psyched them out. And I said, I wasn't trying to. I mean, I really didn't think we were going to settle. And somehow us showing up without anything, basically, we have nothing to lose. We're willing to go all the way. It wasn't just me saying it, it wasn't puffing. You know, we really felt like, hey, you know what? We got nothing to lose because we got to go to trial apparently. And so sometimes it's a tactic that works unintentionally. Yeah.
Any other questions? No? Well, thank you again, guys, for volunteering your time and for speaking. Thank you to everyone who attended, and thank you to Milestone for being a wonderful sponsor.
Yeah.
So if you have any questions or concerns, please let me know. Otherwise, you guys are free.